this was the last discussion that we have done on 94 number question. Okay, and this is the final video lecture. After which we will be able to. After this lecture, there will be no lecture of this particular polity question discussion. Why? Because we will be able to complete in this lecture only. Okay. Then we will be doing separate polity question discussion further in later on in this month only. So let us start today's discussion. So question number 95, consider the following statements with respect to surrogacy rules in India. Okay, so they are asking about the surrogacy rules in India. Since I don't know anything about the surrogacy, so let me read out explanation about the surrogacy. Okay, so here it is. So surrogacy is an arrangement. Surrogacy is an arrangement where a woman, the surrogate, carries and gives birth to a baby for another person or people or couple who are known as the intended parents. The surrogate the surrogate agrees to hand over the baby to the intended parents once it's born. Later, the central government has modified the surrogacy rules 2022. As per the latest amendment, the couple can have a child born through surrogacy but must have at least one gamete from the intended couple. So, statement 1 is correct. Uh, Single women, widows or divorcees undergoing surrogacy must use their own eggs and donor sperm to avail surrogacy procedures. The Act allows access to surrogacy only to two categories of single women, those who are widowed or divorced. Even in these cases, the regulations stipulate that women's own eggs have to be used. So statement 2 is correct. In India, surrogacy is regulated by the Surrogacy Regulation Act 2021. This act prohibits commercial surrogacy. The object of this act is to prevent the exploitation of women who may be lured into the arrangements of commercial surrogacy. Under the provisions of the Act, altruistic surrogacy is permitted, whereby the surrogate mother is required to carry the child to help another individual or couple without receiving any monetary benefit other than medical and insurance expenses. The purpose is to ensure that the procedure of surrogacy remains ethical and transparent and promotes the welfare of all parties involved. So statement 3 is correct. Now additional information surrogacy regulation Act 2021. So the surrogacy regulation Act 2021 defines surrogacy as the practice defines surrogacy as the practice where a female carries and gives birth to a child for an intended couple with the intention of handing over the child to them after birth. Section 2Z. Okay. The Act distinguishes between altruistic surrogacy and commercial surrogacy. Altruistic surrogacy allows now altruistic surrogacy allows only medical expenses and insurance coverage for the surrogate mother or her dependents with no monetary reward. Okay. Now, commercial surrogacy, where the surrogate receives payment or other benefits beyond medical cost, is strictly prohibited to prevent exploitation. Surrogacy clinics and medical practitioners are regulated under Section 4. Only registered clinics can perform surrogacy procedures. Okay. Doctors, embryologists, and other personnel are prohibited from engaging in commercial surrogacy. Abortions during emergency are allowed only with the written consent of the surrogate mother, the registered medical practitioner. So all these things. Now next question number 96. Consider the following statements. Just let me make it a little bit smaller. Yes, I think now it's fine. Now question number 96. Here it is. Consider the following statements regarding the 8th schedule to the Constitution of India. So, 8th schedule, they are asking question. So, the Lok Sabha has recently enabled a simultaneous interpretation of parliamentary proceedings in all 22 languages listed in the 8th schedule. Okay, so you know that 8th schedule is basically related to the 22 languages recognized by the Constitution. Okay. Lok Sabha has recently announced simultaneous interpretation of parliamentary proceedings in all the 22 languages listed in the 8th schedule. Yes, that is correct. Kok Kokborok language has already been included in its schedule. No, this is incorrect. So only one is correct. See, let us see the explanation. Recently, the Lok Sabha Speaker announced that simultaneous interpretation of parliamentary proceedings will now be available in all 22 eight scheduled languages. The eighth schedule of the Constitution mentioned in Article 344 and 351 list 22 official languages. Originally, 14 languages were included in 1950. Later, Sindhi was added in 1967. Konkani, Manipuri, Nepali in 1992, and Bodo, Togri, Mathili, and Santhali in 2003. 92nd Amendment bringing the total 22. So statement one is correct. Recently, Kokborok Sahitya Parishad said the inclusion of Kokborok language in the 8th schedule of the Constitution. The 22 languages that are included in the 8th schedule are Bengali, Gujarati, Hindi, uh, Kannada, Kashmiri, Konkani, Malayalam, Manipuri, Marathi, Nepali, Oriya, Punjabi, Sanskrit, Sindh, Tamil, Telugu, Urdu, Bodo, Santhali, Mathili, and Dogri. Kokborok is one of Tripura's official languages and the mother tongue of the major tribes of the state, including Tripuri, Riang, Jamasia, Ujrao, and Kokoi. At present, the Kokborok language is not included in the 8th schedule of the Constitution. Now, additional information. So, classical language. In the present day scenario, there are 11 languages that are held under the classical status in India. Classical status in India. Okay. So, what are these languages? So, these are Tamil, Sanskrit. You have Tamil. You have Sanskrit. You have Kannada. You have Telugu, you have Malayalam and Odia. Recently, the Union Cabinet approved classical language status to Marathi, Bengali, Assamese, Pali, and Prakrit. All these six languages are listed under 8th schedule of the Constitution. Criteria now. What are the criteria of any language being conferred to the status of classical language? So, this there should be high antiquity of its early text recorded history over a period of 1500 to 2000 years. Okay, a body of ancient literature text which is considered heritage by generations of speakers, knowledge text especially for prose text in addition to poetry, epigraphic and inscription evidence. The classical languages and literature could be distinct from its current form, or could be discontinuous with later forms of the offshoots. Now, part 17 of the official language. So, part 17 of the Constitution contains provisions for an official language for the Union, the state, the judiciary, and the use in intergovernmental communication. Now, language of the Union. So, Article 343. So, official language of the Union. Article 344. Commission and Committee of Parliament on Official Language. Regional languages. Article 345. Official language or language of a state. uh, Language of the Supreme Court, High Court, etc. So all these things you can see. Now next question number 98. Recently, the Election Commission of India announced that it will begin a special intensive revision SIR of the electoral rules in Bihar ahead of its state assembly elections. In this aspect, consider the following powers of the Election Commission of India. Now, Section 16 of the Representative of People Act (RPA) 1950 This with the disqualification for voter registration in the electoral roll. Yes, that is correct. Section 21 of the Representative of People Act, Representation of People Act empowers the ECI to prepare and revise electoral. That is also correct. So both of them are correct. So hence C is the correct answer. Now explanation. So Election Commission of India has announced a special intensive revision of electoral rolls in Bihar before the upcoming assembly elections. The aim is to include all eligible voters and remove ineligible names, ensuring accuracy, fairness in voter list. This exercise follows constitutional provisions and Representation of People Act 1950. Article 326 grantees universal adult suffrage, while Section 16 of the RPA lays down disqualifications such as non-citizenship, unsound mind declared by court, disqualification due to corrupt practices or election offences. So statement 1 is correct. Section 21 of the Representation of the People Act 1950 empowers the Election Commission of India to prepare and revise the electoral rules for every constituency. The law provides that the electoral roll must be revised before every general election to the Lok Sabha or State Assembly, before every by-election to fill a vacant seat. The electoral roll may be so all these things you can see. Now, a special intensive revision. What is this? So, according to recent notification of the Election Commission of India, this is the first intensive revision of Bihar rules since 2003, and also aims to maintain the integrity of the electoral roll as it is fundamental for the conduct of free and fair election. It aims to achieve three things in Bihar: that every eligible citizen is enrolled and no is excluded, no one is excluded, no ineligible voter remains on the rolls; to eliminate date shifted absentee voters. The Election Commission of India has justified this intensified exercise, citing factors such as rapid urbanization, frequent migration, the addition of newly eligible young voters, under the reporting of deaths, and inclusion of names of foreign illegal immigrants. So now constitutional provision regarding election. So Article 366, Article 326 provides that every citizen of India who is 18 years or older has the right to vote subject to disqualification prescribed by law. Article 324 vests the Election Commission of India with the superintendence, direction and control of election of India. Now next question, which is question number 99. Which of the following writs can be issued against administrative authorities? So this is the certiorari and mandamus. Okay, let us see the explanation. So the Supreme Court under Article 32 and the High Courts under Article 226 can issue the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Okay, now mandamus. So mandamus is issued to compel a public authority, government official, or lower court to perform a public duty, or act in accordance with the law. It is issued when a public authority has failed to carry out its statutory duties, or an official refuses to act as required by law. Writ of mandamus can be issued against a public or government authority, okay, that has not performed its legal duties. It does not apply to private individual but only to public authorities or bodies. Now, certiorari, the writ of certiorari is issued by a higher court to a lower court, tribunal, or authority, administrative authority, quashing or correcting a decision or order that is deemed to be made without jurisdiction, or in violation of principle of law. Initially, the writ of certiorari cannot be sued against the administrative authority. However, in 1991, the Supreme Court clarified that this writ cannot be issued against purely administrative action. This implies that it can be invoked only in those situations where it is concern authorities' duty to act judicially after hearing both the parties and without any extraneous considerations. Okay, so that is the now prohibition. The writ of prohibition is issued by higher court, usually Supreme Court or High Court, to a lower court or authority to stop it from acting beyond its jurisdiction. It is issued when a lower court tribunal authority is proceeding to the matter that is outside of its jurisdiction or competence. Thus, statutory and mandamus can be issued against administrative authority. So B is the correct. Now, additional information. So its types. So Article 32 deals with the right to constitutional remedies or affirms the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights contained in Part 3 of the Constitution. Okay, so all these things you can see. Now, this is the last question, that is 100. Consider the following principle. How many of the above have been held by Supreme Court to be part of basic structure? So, welfare state, yes. Dignity of individual, yes. Integrity of state, yes. Parliamentary privilege, no. This is not the part. So, three of them are correct. Now, let us see the explanation. So, in 1973, a 13 judge constitution bench ruled in Keswanda Bharti versus State of Kerala that Article 368 of the Constitution does not enable Parliament to amend the basic framework of the document. The historic ruling came to be known as Basic Structure Doctrine, a judicial principle that the Constitution has certain basic features that cannot be altered or destroyed by amendments by Parliament. From the various judgments, the following have emerged as the basic feature of the Constitution or elements of basic structure. What are these? So, supremacy of the Constitution, welfare state, socio-economic justice, judicial review, freedom and dignity of the individual, unity and integrity of the neighbors. Hence, 1, 2, and 3 are correct. Supreme Court of India has not held a parliamentary privilege to be the part of basic structure of the Constitution. Okay, so parliamentary privileges in India are outlined in Article 105 and 194. Parliamentary privileges are special rights, immunities, and exemptions enjoyed by two houses of parliament, their committees, and their members. So, statement 4 is not correct. So, let us see the additional information. Basic structure of the constitution. The present position is that the parliament under article 368 can amend any part of the constitution including the fundamental rights but without affecting the basic feature of the basic structure of the constitution. However, the Supreme Court is yet to define, clarify what constitutes the basic structure of the constitution. Okay, so this is the basic present position. From the various judgments, the following have emerged as the basic features of the Constitution or the elements of the basic structure. Okay, of the Constitution. What are these? So, supremacy of the Constitution, sovereign, democratic, and republican nature of the Indian polity, secular character of the Constitution, separation of powers between legislature, executive, and judiciary. Then federal character of the Constitution, unity and integrity of the nation, welfare state, judicial review, freedom and dignity of the individual, parliamentary system, rule of law, harmony and balance between fundamental rights and directive principle of equality, free and fair elections, independence of judiciary, limited power of parliament to amend the constitution, effective access to justice, principles or essence underlying fundamental rights, power of Supreme Court under Article 32, 136, 141 and 142, powers of High Court under Article 226 and 227. Now, parliamentary privileges. So, parliamentary privileges refer to special rights and immunities enjoyed by MPs as a parliament as an institution and by MPs as an individual, namely to carry out their constitutional function without external interference. These privileges are two types: collective privileges and individual privileges. Collective privileges enjoyed by each house of parliament, individual privileges enjoyed by members themselves. Now, the constitution basis lies in Article 195 for Parliament and 194 for state legislature. Article 105 clause 2 and 194 clause 2 protect MPs MLAs from legal proceedings from for anything said or any vote given in the House or its committees. Also, no liability arises for official publication of the House proceedings. Now, Article 105.3 and 194.3 state that the Parliament or the state legislature may define privileges by law. Okay, so all these things. I hope now things are clear. So, 100 question this question discussion we have done. Okay, we just not only just discuss the question, but also we understood the explanation of all those 100 questions. Okay, with the exception of two or three questions that we have skipped, which were not part of polity. Okay, they were related to the schemes. Okay, so thank you very much. The next video discussion that I will be bringing is will be on the modern history. Okay, thank you.